My name is Michelle Utino, and I'm an international investment arbitration intern here at the Lata Center for International Law and Comparative Constitutionalism in Africa. I am looking forward to having an insightful discussion centered on the Al-Kharafi case. Thank you.
Thank you so much, Michelle. Mimunat, the floor is yours. Please introduce yourself.
Can you hear me?
Yes, I can hear you.
Okay, good evening, everyone. My name is Mimunat Olabore, and I am an intern at Lata Center, and I'm specializing in international arbitration. And I hope today's session is going to be very insightful and we'll be able to take one or two knowledge from international arbitration and the Al-Kharafi's case in general. Thank you.
Thank you, Mimunat. So for our audience, I would advise that if you have any questions, you just write them down or you can drop them in the chat box. After our panelists are done speaking, after they've exhausted the questions being asked to them, then we would address the questions from the audience. If you don't want to write your questions down and you prefer to say it by yourself, then you will also have an opportunity after they've exhausted the questions for this panel session. All right, so we would get right into the core of today's events. And I would now ask, firstly, Michelle, could you please discuss very briefly the facts of the Al-Kharafi case, including the main arguments of the parties and the decision of the tribunal?
Thank you for the question. So the Libyan Ministry of Tourism granted the plaintiff company Al-Kharafi an approval and license to operate, to establish a major tourism investment project in Tajura in Tripoli. And this project, it envisioned the development of a five-star hotel, a commercial center, apartment, and recreational facilities. So they then signed a contract number 4, which leased the land for 90 years for purposes of establishing this project. And that contract contained an arbitration clause, Article 29, which stated that in the event of a dispute between the parties, that dispute shall be resolved amicably, and failure to which that dispute shall be referred to arbitration pursuant to the Unified Agreement for the Investment of Arab Capital in the Arab States. So this project experienced interruptions such as police action, municipal guards, and parties who claimed rights over the land. And the company reported these incidences to the Libyan authorities, but they proposed the relocation of the project, which the company rejected. So later on, the Minister of Industry, Economy and Trade annulled the investment approval, and it cancelled the project and withdrew the license. So Al-Kharafi had sought clarification, and they attempted to engage them through multiple correspondence and formal notices. And unfortunately, these efforts failed. So they invoked the arbitration clause under Article 29 of the contract. So an ad hoc arbitral tribunal was formed, and it had its seat at Cairo, and it applied the Cairo Regional Center for International Commercial Arbitration Procedure rules. So I'll move on to the arguments, and I'll start with Al-Kharafi. So they first stated that Libya's revocation of the investment approval was unlawful and arbitrary, and it amounted to expropriation and breach. So they reiterated the fact that they had transferred capital into Libya. They had already invested in the project, yet it was cancelled abruptly. They also argued that Libya breached its contractual obligation to deliver the land free of impediments, arguing that various events such as the police action directly impeded its ability to continue with the construction. They also argued that the Unified Agreement for the Investment of Arab Capital in the Arab States formed part of Libyan law, and it was incorporated in the contract. So it was binding on Libya and all its organs. And they sought compensation for the moral damages, for reputational harm, lost profits, arbitration costs, and the costs, totaling $2.055 billion US. So I'll move on to the arguments of Libya, the government of Libya. So they argued that the arbitration was premature since local remedies were not exhausted. So according to them, amicable settlement meant that there was a precondition of consent did not occur. So they argued that the dispute was premature and the case should therefore be thrown out. They also argued that the unified agreement applied to only to investments involving actual capital transfer, and Al-Kharafi had not made any investments into Libya. They argued that the tribunal lacked the jurisdiction and that the arbitration clause could not be respondent entities, especially the Libyan Investment Authority. And those disputes, certain disputes were matters of administrative sovereignty, which were not arbitrable under international law. Lastly, they argued that the cancellation of the project was lawful since Al-Kharafi failed to initiate the project within the prescribed timeline. So it's triggered the state's right to invoke the investment license under their law, the investment law. So the decision of the tribunal. So the tribunal found that the Libyan government, along with its Ministry of Economy, General Authority for Investment, Promotion, and Privatization Affairs, and the Ministry of Finance were jointly and severally liable for the plaintiff approximately $937 million US as compensation to account for the damages and loss that occurred to them. Thank you.
Thank you so much, Michelle. That was a very thorough recital summary of the facts. I think that our audience would be relatively well acquainted now with what we'll be discussing moving forward. And I'm just going to pick on one part of the facts that you've recited to us and use that to catch a question to Memunat. And the question I have for you, Memunat, is from an international arbitration perspective, why was the unified agreement a viable basis for bringing these disputes to arbitration, despite the existence of a lease contract?
Thank you very much, Betty, for that question. And my opinion is that from an international arbitration perspective, the unified agreement for investment of Arab capital in Arab states was a viable means of bringing Al-Kharafi's disputes to arbitration because it actually forms part of Libyan law and it expressly governs disputes between disputes involving investments by Arab investors in Arab states. And even though the lease contracts between Al-Kharafi and the Libyan Tourism Development Authority contained an arbitration clause, that's Article 29 of the contract, the clause referred disputes to arbitration on that unified agreement if amicable settlement failed, right? So this meant that the tribunal could address not only disputes over the lease, that is the interpretation or performance of the lease, but also they could touch on broader issues such as the cancellation of the lease contract, the actions of the Libyan authorities that actually affected the project. And the unified agreements also provided a recognized legal framework under Libyan law that allowed the tribunal to actually exercise jurisdiction over the Libyan states and affiliated authorities like the Tourism Development Authority, and to also ensure that the arbitration could cover all relevant investment-related claims. And without the arbitration clause, without the unified agreements, the arbitration clause in the lease might have been limited in scope, and that would have restricted the tribunal to technical questions about the lease rather than the actual broader investment disputes.
All right, thank you so much, Memunat. And I just for our further context for our listeners, in this particular case, there were two arbitration clauses. So basically, there was one in the unified agreements, which is a BIT, which serves as a BIT, and then secondly, in the lease contracts, which was drafted between both parties. So thank you very much, Memunat, for that answer. And I would just like to ask a follow-up question, still bordering on the tribunal's decision, or where they drew their jurisdiction from. The question is, where exactly did the tribunal locate Libya's consent to arbitrate? And why was that decisive for the tribunal's jurisdiction?
Oh, can you hear me now?
Yes.
Okay. The tribunal located Libya's consent to arbitration in the arbitration clause of the lease contracts, right, between Al-Kharafi and Libyan Tourism Development Authority. And Article 29 of that contract stated that any disputes arising from the interpretation or performance of the contracts should first be settled amicably, right? And if that failed, then they referred to arbitration under the unified agreement. So the clause was actually decisive because it's linked the parties' agreements. It linked the parties' agreement to arbitration under the unified agreement, which is also recognized as part of Libyan law. And by referring dispute to the unified agreement, Libya, through its entities and affiliated authorities that were involved in the lease, was considered to have submitted to arbitration or consented to submit to arbitration. And, allowing the tribunal to assert jurisdiction over the state and its agencies, and even for disputes extending beyond mere interpretation or performance of the lease, which included determination of the project and related damages. So, yes.
Thank you very much, Memunat. In this present case, we see that the arbitration clause, as was earlier stated by our panelist, it was multi-tiered. And so it said the arbitration agreement in the lease contract, to be specific, stated that the parties would first try to resolve their disputes through amicable settlement, which is a rather vague term. And then if that doesn't work, then the parties would go to arbitration in order to resolve their disputes. And so I would just like to ask you, Michelle, this question. How did Libya rely on the amicable settlement requirement to challenge the admissibility of the claim? And why did the tribunal reject that submission by the respondents?
Okay, thank you for the question. So Libya interpreted amicable settlement to mean a formal conciliation or a negotiated settlement process, so a formal process of settling the dispute. And they stated that the arbitral proceedings were premature since the claimant, Al-Kharafi, did not engage in that formal conciliation process. So the tribunal looked at three basic things when they were interpreting the case. They looked at the interpretation of the term amicable settlement, the distinction between the term amicable settlement and conciliation, and the factual compliance of the claimant, whether the claimant complied with their meaning or their definition of the term amicable settlement. So they held that, I'll start with the interpretation of amicable settlement. So they stated that there was no reference. Article 29 of that contract did not provide any reference to a formal conciliation process, whether there was a time frame, a designated institution, or a specific procedure. and they stated that if the drafters intended that they were going to require a mandatory conciliation, they would have stated it explicitly. They also looked at the distinction between the term amicable settlement and conciliation. They defined amicable settlement as a general obligation of good faith attempts or efforts to resolve a dispute, whereas conciliation was a formal dispute resolution mechanism that has express procedure rules. So both the unified agreement and the contract referred solely to amicable settlement. So the tribunal refused to imply a mandatory conciliation that was not expressly stated in the contract and the unified agreement. Lastly, they looked at the compliance of the claimant. So they looked at whether the amicable settlement requirement had been satisfied by Al-Kharafi, and they noted the correspondence between Al-Kharafi and the Libyan authorities, and the meetings and formal notices, as well as the petitions that requested land handover and takeover and protection. So it held that amicable settlement requirement did not mandate a formal conciliation, and instead construed amicable settlement to mean good faith attempts to resolve the dispute, which the Al-Kharafi had satisfied. So therefore, Libya's admissibility objection was rejected. Thank you.
Thank you very much, Michelle. I think that answer was really satisfactory. But we also, on that note, and just to add to what you've said really briefly, that particular clause in the lease contract, the Article 29 that stated amicable settlements, also stated that the tribunal has the power to interpret the contract. So the parties not having a meeting of mind as to what exactly amicable settlement meant, then gave the tribunal the power to interpret that particular clause or phrase in the contract, and that's what the tribunal had rightly done by not tying it to any formal type of dispute resolution. And I'm just going to stay with you, Michelle, before I ask before I move to Memunat. And the question that I have for you now is, why didn't the tribunal treat the lease arbitration clause as the lex specialis governing the consent and jurisdiction, even though it was directly negotiated by the parties? And again, for the sake of our audience, just for more context, our panelists had already mentioned that there were two separate arbitration clauses, one in the lease contract and another one in the unified agreement, which serves as a BIT in this case. So, Michelle, again, the question is, why didn't the tribunal treat that lease agreement and the arbitration agreement in the lease clause as lex specialis and therefore more binding on the parties?
Thank you for the question. So lex specialis is a legal principle that provides that a specific law overrides general law when both of them apply to the same situation. So Article 29 was negotiated between both Al-Kharafi and the government of Libya, but was expressly incorporated under the unified agreement. So it therefore did not operate in isolation, did not operate alone. So the tribunal held that the unified agreement was part of Libyan law, and it was therefore hierarchically superior arbitration clause.
Okay, I think that your network shook a bit, but I think that the point we were trying to make was that the arbitration clause in the unified agreement, the tribunal decided had a higher hierarchy as compared to that of the arbitration clause in the lease contracts. Did I get that right? Is that what you said?
Yes.
All right. Thank you so much. As a Memunat, I will now move to you, but still on this same topic, on this discourse of the arbitration clauses in these two contracts. The question to you now is, how did the tribunal characterize the relationship between the lease arbitration clause and Article 29 of the Unified Agreement as a conflict, a hierarchical order, or did the tribunal decide that they could coexist? And Michelle has touched a bit on the hierarchy, but could you expatiate on this a little bit?
All right, thank you very much. I do not think that the tribunal treated the relationship between Articles 29 of the lease and Articles 29 of the Unified Agreement as a conflict. Instead, it's treated the two provisions as operating in a hierarchical and complementary way, with Article 29 of the Unified Agreement prevailing for jurisdictional purposes. Article 29 of the lease contract was narrow. It's limited arbitration to disputes arising from the interpretation and the or performance of the lease, and it expressly also referred dispute to arbitration pursuant to the Unified Agreement. On its face, right, this clause could be read as a less special lease because it was directly negotiated by the parties, right, and confined arbitration to contractual disputes. However, Article 29 of the Unified Agreement was broader. It's granted jurisdiction over any dispute arising from the application of the agreement. And this included disputes between an Arab investor and a state or its public institutions. So this provision clearly extended beyond contractual issues, and it covered state responsibility for interference with an investment. So the tribunal rejected the argument that the lease clause as less special lease should limit jurisdiction. It reasoned that by expressly referring disputes to the Unified Agreement, like referring dispute to arbitration under the Unified Agreement, the parties had incorporated the agreement's dispute settlement regime in full, and this included its broader jurisdictional scope. So the view of the tribunal was that once the Unified Agreement was engaged, its Article 29 determined jurisdiction and not the restrictive wording of Article 29 of the lease. Thank you.
Thank you very much, Memunat. I think that are the points that we also need to note. The arbitration clause in the lease agreement referred or referenced to the arbitration clause in the Unified Agreement. And so the tribunal took both of them as one and interpreted them as a whole. But still on this same matter of discussion, could that limitation in the lease contract realistically have constrained the tribunal's jurisdiction in this case? And do you think that it actually should have in this case?
Well, I do think that Article 29 of the lease contract, right, it permits arbitration only for disputes arising from the interpretation or performance of the lease during its validity. So its scope is therefore, in my opinion, clearly contractual, and it is narrow. So it does not, on the ordinary face of it, extend to disputes about other issues, other broader issues like state responsibility, regulatory interference, and the other broader investment issues. So that limitation could realistically have constrained the tribunal's jurisdiction in this case if Article 29 of the lease were treated as the controlling source of consent. The tribunal would have been confined to deciding whether Libya, through contracting authority, had breached specific obligations under the lease. And we know that this matter is way more than that, right? So claims relating to maybe police harassment, actions of different authorities, cancellation of the investment license would have fallen outside the clause, right? Because they go beyond the mere interpretation or performance of the contract. So I think the tribunal did not allow this limitation to control its jurisdiction. It reasoned that Article 29 of the lease did not stand alone, but it expressly referred dispute to arbitration pursuant to the Unified Agreement. So by doing so, the tribunal treated the lease clause as a procedural gateway rather than a substantive restriction, and it allowed the broader dispute settlement framework of the Unified Agreement to determine jurisdiction. And okay, the question has a second part, yes, whether it should have constrained jurisdiction. I think that is contentious, right? From a strict consent-based arbitration perspective, there is a strong argument, right, that the tribunal should have respected the contractual limitation, especially since the lease clause was directly negotiated and carefully drafted by the parties. But allowing the broader treaty framework to override that limitation, in my opinion, is risk diluting party autonomy. And we know that in arbitration generally, it is a core principle that the parties have autonomy over the, less especially over the law, over the arbitrators to decide their matters, right? So, but on the other hand, given the express reference to the Unified Agreement and the statewide nature of the alleged interference, the tribunal justified its approach as necessary to address the real substance of the dispute, which extended well beyond a simple contractual disagreement.
Yeah, thank you very much, Mimonas, for that answer. And you made a statement. You said the tribunal did not allow this to affect its jurisdiction, and I'm just wondering whether or not there was anything in this case that the tribunal even allowed to actually affect its jurisdiction, because this was not the only contention that the tribunal faced. In this case, it seems like the tribunal had consistent hurdles just to ensure that it could even hear the case at all. And so I'm just going to piggyback to the issue of amicable settlements, because that was another hurdle that the tribunal had to get past before they even got to the substance of the case. And although that isn't necessarily linked to jurisdiction, that's an issue of admissibility. Nonetheless, it would still affect the tribunal's ability to hear the case. And so I will just pose this question to both you and Michelle. And in your opinion, do you think that the tribunal reasonably interpreted amicable settlements, and did it consider conciliation to be mandatory? So what respondent had stated basically was that what amicable settlements is a process of dispute resolution, and then the tribunal declined. So I just want to get your own personal opinions. If you were the tribunal, would you have interpreted it the same way that the tribunal in this case did? And secondly, do you think that the tribunal disregarded all of respondents' contentions simply because it wanted to hear this case? Or was there reasonable ground?
Am I going first?
Yes, please.
Do I go first?
If you don't mind.
Okay, thank you very much. On this question, right, it borders on how did the tribunal give their meaning to amicable settlements, right? And did it actually consider conciliation to be a mandatory form of settlement under that wording? So I think the tribunal interpreted the phrase amicable settlements in the lease as a general requirement to try resolving disputes, right, without litigation. It was not an option, right? But I don't think the tribunal treated conciliation as strictly mandatory. My reason is because the tribunal reasoned that the lease clause did not specify how the amicable settlement should be conducted, right? It didn't specify how long it should last or which officials must participate. So the tribunal concluded also that Al-Kharafi's prior efforts to communicate, right? There were correspondences exchanged. So they considered Al-Kharafi's prior efforts to communicate and negotiate with Libyan authorities as sufficient to satisfy the amicable settlement requirement. So it rejected Libya's contention because they were going to hinge on the fact that, oh, amicable settlements has not been exhausted and we are moving to arbitration, right? So the tribunal concluded that it rejected Libya's objection that the arbitration claim was inadmissible due to failure to conciliate. And in effect, I just think that the tribunal treated amicable settlement as a flexible procedural step and not a strict precondition that could block arbitration, right? And in my opinion, I definitely do agree with them. Amicable settlement didn't have a specific definition. How do we go about this amicable settlement? And it also didn't state whether it should be conciliation, mediation, and looking at the fact of the case and the surrounding circumstances, they look at the fact that Al-Kharafi has tried through their correspondences and communication with the Libyan government to try to resolve the issue. So that was, in their opinion, the opinion of the tribunal, enough to satisfy the amicable settlement requirements. Thank you.
Thank you, Memunat. And I recognize that we've been on you for quite some time. So just give you a little bit of space to breathe a bit and we'll move to Michelle. So Michelle, just the same question. Just want to get your opinion on this. And feel free to disagree with Memunat and the tribunal even. All the more exciting if you do.
I agree with both Memunat and the tribunal. So the tribunal used the term amicable settlement is too broad to actually determine what it is, and the court construed amicable settlement to mean good faith attempts and effort to resolve the dispute. So all the actions that were involved to resolve the dispute in any manner. So the claimant Al-Kharafi had years of correspondences, petitions, as well as letters and meetings. So that could be interpreted as amicable settlement. They had made an attempt to resolve the dispute. I agree that it should not, amicable settlement did not. I agreed with the tribunal's a decision not to consider conciliation as mandatory, considering that Article 29 of the contract did not provide a specific means, procedure, or timeline in a designated institution, which were required for mandatory conciliation. So I think that the tribunal's decision was okay, it was good, and that amicable settlement did not mean conciliation was mandatory. Thank you.
Thank you, Michelle. I was really hoping that you would disagree with Memunat and the tribunal so that we can have our own mini conflicts just within the panel. But I can disagree and say that, well, amicable settlements could also, it could be implied that the parties used the term amicable settlement because they were trying to prevent it meaning litigation. So they might have meant conciliation, or negotiation, or mediation, any other formal process of dispute resolution except litigation, which is notorious for not being synonymous with amicable settlements. But then, nonetheless, I think that the arguments or the decision could have gone either way. And again, the parties themselves had given the tribunal the power to interpret the contract, and competence allows the tribunal to decide whether or not it has jurisdiction. Ultimately, it's reasonable that the tribunal took that stance. So thank you to both of you. Michelle, I'm going to stay with you and direct the next question to you, which is, what legal principles did the tribunal rely on to attribute the conduct of different Libyan authorities and security organs to the Libyan state? Because I mean, respondents thought otherwise. Respondents themselves tried to make a distinction and said, well, that's not what that did all the harm that you're pointing to. So how did the tribunal address that attribution?
So I'd say the tribunal relied on 4 legal principles: due diligence and effective protection standard, the attribution of conduct of state organs, the unity of the state under international law, and the attribution through tolerance and acquiescence. So I'll start with due diligence and effective protection standard. So the tribunal held that Libya had an obligation to organize its security organs and administrative organs effectively, and the inability of these organs to act in a coherent manner did not excuse responsibility. So they stated that, or they emphasized that a state cannot escape responsibility by pointing to the disorganization of its own institution. And they held that systemic dysfunction itself constituted a breach. So the next principle they relied on was attribution of conduct of the state organs. So there are various state organs such as the police forces, the municipal guards, security services, and administrative authorities. And their acts and omissions were attributable to the state. They interfered with the construction of the project. So whether they acted pursuant to instructions in each other, they were next, the unity of the state and internal law. So they stated that the acts internal divisions between these police, security bodies, and ministries are not relevant to international responsibility. So Libya cannot rely on its internal administrative disorganization to avoid responsibility. Lastly, attribution through tolerance and acquiescence. So they stated that state responsibility arises from direct action, but it also arises from tolerance, a failure to exercise authority, and acquiescence. So where the Libyan authorities were aware of the interferences with the construction, they had the capacity to act on it, but they failed to provide protection, and this was legally attributable to the state.
Thank you, Michelle. That was a really brilliant answer, and it definitely shows that you paid key attention to the principles that the tribunal applied. There were lots of principles. But one thing has come to my mind that I think that the tribunal could also have leveraged on, which is the ILC draft articles on state responsibility for internationally wrongful acts. That might be a body of law, although soft law probably in this case, that the tribunal would have relied on to attribute the actions of those organs of the state to the states. It's all expressly contained in those articles. But again, soft law, so nonetheless. But the tribunal did rely on sufficient principles, and I think that still got it to the point in which it was trying to get to. Thank you again, Michelle. My next question is to Memunat, and the question is, what law did the tribunal apply, firstly, to the arbitration proceedings, and secondly, to the substantive obligation and claims? Were these choices implied, or were they expressly stated by the parties? And before you answer, again, for more context, and for those that might not know this, the laws that apply to arbitration proceedings may differ from the laws that apply to the merits of the case. So Memunas would be expatiating on the two laws that apply to those two parts of the disputes. You can go ahead.
Well, thank you very much, Betty. The tribunal applied different legal frameworks, right, to the two aspects of the cases. So, for the arbitration proceedings, it relied on the rules of the Cairo Regional Center for International Commercial Arbitration, right? Because the president of the tribunal unilaterally selected Cairo, Egypt, as the seat of the arbitration. And he chose these rules as the procedural law governing how the arbitration would be conducted, right? So this choice provided the tribunal with a structured set of rules for procedural matters such as the conduct of hearings, submission of evidence, and the rendering of the award. But for the substantive law, right, the tribunal primarily applied Libyan law in combination with the Unified Agreement for the investment of Arab capital in the Arab states. So the lease contract between Al-Kharafi and the Libyan authorities included a reference to the Unified Agreement in its arbitration clause. So the tribunal concluded that the agreement had been incorporated into Libyan law through ratification. So while the tribunal acknowledged the potential applicability of administrative law, it's determined that the lease was a BOT style, that is build, operate, transfer style commercial contracts, which are subject to Libyan civil code and not an administrative contract. So it was thus governed by domestic law principles on contractual liability, right? So on the procedural law, I don't think it was expressly settled by the parties to go with the Cairo Regional Center for International Commercial Arbitration, right? Because I earlier mentioned that the president of the tribunal unilaterally selected Cairo as the seat of the arbitration. So for the substantive obligation and claims, I would say this choice of law was express. Yes, it was limited, but the fact that it still referred to the Unified Agreement, which gave it a broader
Nominat, you've frozen a bit. I think your network, and I hope it's not me. We unfortunately cannot hear you. Nominat, can you hear me? Can you hear me?
I know.
I think it's getting better, but it's still. Oh, did she? I think that she dropped off. So we'll just give her about a minute to join back. Hopefully, it will all be sorted and we can proceed. But I had a follow-up question for her. Okay, she's back.
Oh, I'm sorry. What was the last thing you heard me say?
You were the last thing that we audibly heard was when you referred to the tribunal, the president of the tribunal presiding arbitrator selecting the seats of arbitration.
Oh, okay. So I'll just briefly summarize what I said earlier, that the tribunal applied different legal frameworks to the two aspects of the case. For the arbitration proceeding, it relied on the rules of Cairo Regional Center for International Commercial Arbitration, right? Because the president of the tribunal unilaterally selected Cairo, Egypt, as the seat of the arbitration. So he chose these rules as the procedural law governing how the arbitration will be conducted. And for the substantive law that govern the claims and obligations of the parties, the tribunal primarily applied Libyan law in combination with the Unified Agreements for the investment of Arab capital in the Arab states. And we shouldn't forget that the lease agreement between Al-Kharafi and the Libyan authorities included a reference to the unified agreement, right, in its arbitration clause. So the tribunal concluded that the agreement had been incorporated into Libyan law through ratification, right? So I would say for the procedural part, the parties may not have been expressly clear on that, on the law that governs the procedural aspect, but for the substantive issue and for the substantive claims and obligations of the parties, I would say to an extent, they were able to agree on that, and it was express. So it also mentioned the unified agreements, which ended up broadening the scope of the case at the end of the day.
All right, thank you, Memunat. And I actually have a follow-up question to you.
Okay.
You mentioned that the president of the tribunal, or the presiding arbitrator in this case, had selected the seat of arbitration for the parties. And my question now is, do you think that affects party autonomy? Is that not a decision that the parties should have made? And does that inability or the refusal by the tribunal to allow the parties select their own seats disturb the sanctity of this arbitration proceeding?
I think to say that it disturbs the sanctity of the whole arbitration proceeding is quite a reach. The parties themselves did not expressly talk about the laws or the framework that should govern the procedural aspects. So I think it was just the tribunal trying to assume jurisdiction and also to settle all the matters in an efficient manner was the reason why they came up with, oh, let's use Cairo as the seat of the arbitration and let it govern the procedural aspects. But I do agree that it quite disturbs the principle of party autonomy that I've earlier mentioned, and seeing how it's a core principle and element of arbitration. We could debate it, right? But I don't think we can say that it disturbed the whole sanctity of the arbitration proceeding.
All right, thank you, Mimnas. And we'll turn back to you, Michelle. And the question is, what standard did the tribunal apply in assessing Libya's responsibility for the failure of the project? And why was that standard decisive in this case? We are actually we're not out of time just yet, but we're almost out of time. So if you could answer this question as briefly as possible, that would be great.
So the tribunal applied the due diligence and effective protection standard that I earlier mentioned, and under this standard, Libya had certain obligations, some of them being that they were to ensure handover and takeover of the land, and to coordinate the authorities effectively, prevent third-party interference, and protect the investors' rights. Why the decision was decisive? So the tribunal had stated that a state is responsible when it fails to make its administration function coherently. And although Libya did not directly order the interference, its inaction, tolerance of obstruction, and conflicting instructions amounted to systemic failure.
Pardon me. I didn't realize I was muted. But thank you for that really brief answer. I would now open the floor for questions from the audience. Feel free to put them in the chat box below, or you can unmute and ask your question to both or either one of our panelists. Are there any questions from the audience? Okay, I will take that as a no. However, we still have about, okay. All right, so we do have a question from the audience, and I will direct that to both of our panelists. What is your greatest takeaway from this matter? In relation to investment arbitration, of course.
Can I go? Can I talk?
Sure.
Okay, thank you. For me, I would say the biggest takeaway from the Al-Kharafi's case is that investment arbitration can hold a state responsible for systemic interference across multiple agencies and not just isolated contractual breaches, especially when there is a regional investment framework like the Unified Agreement. So this case shows that tribunals can interpret arbitration clauses and investment treaties broadly and link the conduct of state entities to the state itself and award comprehensive compensation. Well, they still have to respect the limits of their remedial powers. So maybe remedies like specific performance may not be readily available, right? But for damages, for moral costs, that could be readily available under investment arbitration. So, and I think for investors, it highlights the importance of carefully drafting agreements and relying on regional or international investment protections. And then for states, it underscores the need to coordinate actions of all government bodies and to also respect investors' rights to avoid liability. There should also be a very comprehensive system of documentation.
Thank you very much, Mimunat. Michelle, over to you.
So I'd say my key takeaway from this case is that it reaffirmed one of the important principles of law, which is the rule of law, respect for the rule of law, and I'll relate it to regional investment arbitration. So applying AVDICE's three principles, which are supremacy of the law, equality before the law, and predominance of the legal spirit. So when it comes to supremacy of the law, so the tribunal held the supremacy of the law when it refused to excuse Libya's administrative fragmentation. The excuses of some of its organs being disorganized, not being attributed to Libya as a whole. It also affirmed since Libya was a state entity, therefore it was allowed. It was not exempt to be obedient or to the law. And Libya, the tribunal attributed liability across various ministries within the Libyan government. So it affirmed the principle of equality before the law. And lastly, the predominance of legal spirit, where they gave a real effect to the Arab investment treaties, where they incorporated moral damages to the compensation of Al-Kharafi. Thank you.
Thank you, Michelle. We actually have one more question in the chat box, but before I ask it, I recognize that I'm not one of the panelists, but I will give my takeaway from this case. I think that it's important for investors to carry out their own due diligence, which claimants could have done and perhaps might have avoided this entire issue. And secondly, just the ability of lawyers to preempt possible contractual issues. The tribunal had to do a lot of interpretation of the contract because a lot of terms were really unclear, and that goes to the drafters of the arbitration and the agreement. So I would ask the final question before we wrap up the session, and I would oblige both our panelists to answer. The question is, to what extent does the tribunal's decision reinforce the principle of sanctity of contract? So Michelle, you can go first, and then we would go to Memunat for a response. Michelle, can you hear me? Okay. Michelle, can you hear me? Could you kindly answer the question in the chat box? The question is, to what extent does the tribunal's decision reinforce the principle of sanctity of contracts? I think it's a really important question, considering that the tribunal has to do a lot of inferring, interpretation, and even selection of the seat of arbitration. So could you kindly answer? Michelle, can you hear me? I think that she's frozen. So Mimuna, please answer the question, and hopefully in the course of your response, Michelle would sort out the network issues, and then she can answer after you.
Okay, the question was, to what extent, right, did the tribunal's decision reinforce the principle of sanctity of contracts? Okay, I would say to a limited and qualified extent. Because on one level, the tribunal affirmed sanctity of contracts by holding Libya liable for failing to perform its contractual obligations, right, under the lease. So it treated the lease as a valid and binding agreement and found that the states and its authorities breached the contract by, failing to deliver the land free of encumbrances, and also by terminating the lease without lawful justification. So I think, however, the tribunal did not treat the contract as the exclusive or controlling framework of the disputes, right? It declined to confine its jurisdiction to the narrow wording of Article 29 of the lease contract, right? So he had to rely heavily on the unified agreement to expand the scope of the dispute to include state responsibility beyond the contract. So I think by doing so, the tribunal shifted the case away from pure contractual sanctity towards a broader investment protection analysis. So I think the approach, it is debatable, but in my opinion, I think it diluted, the classical sanctity of contract.
Thank you, Mimunat. Michelle, if you could please respond now. Would you like me to repeat the question, or you want to go right into it? Oh, I think that she's frozen again. We're actually out of time, but I could try to stall for about 30 seconds or a minute just to see if she's able to get it sorted. I think we can just give her about a minute, and if she's not able to join back, then okay. Okay. Unfortunately, Michelle was unable to answer that question, but thank you very much, Mimunat, for that answer. And thank you very much to all our participants, our listeners, to those that will watch this as a YouTube video afterwards. We had a really insightful session, and I'm very sure that all our listeners and participants had a lot to take away from this particular session. I know that you've learned quite a lot about international investment arbitration. It really was a brilliant session. Thank you again for joining. I think that we can call it a day, and we have come to the end of this session. Thank you.